Okay, in a great amount of detail, probably because it can be its own presentation, but I am going to touch on it as it sort of intersects with the other duties and how it comes into play. As you can see there, we're going to go over fiduciary duties in the background to director duties and how they came about, duty to act with reasonable care and diligence, in good faith and in the best interest, the common law duty of loyalty owed by directors, duty to avoid improper use of position and information, together with the consequences if a breach does occur, and some tips on how to avoid a potential breach. Hey. Okay, so just a bit of an overview. What are director duties? So on a very basic understanding, it refers to the way in which a director manages a company and the obligations imposed on those directors. We will touch upon some of those obligations today, as I just mentioned. The way the director duties have been drafted and interpreted by the courts do try to encourage entrepreneurism together with balancing inappropriate risk-taking and blind management. So we will touch upon consequences as well. It is important to note that when determining consequences, the courts work on a sliding scale. So if a director has been a director for 20 years and has, a background of financial, like accounting experience, that director is going to be held at a higher standard than a sort of director of a startup who has never seen a financial document in their life and is looking to outsource. It'll still be a breach, but their consequence will be on a much smaller scale. So, background, how did director duties come about and where do we find them? Unfortunately, as with most litigation and legislation, there is no one single source to find a director duties. A person will have to turn to common law or general law, where that duty of loyalty arose. They come from equity and trust laws, as well as the Corporations Act, which is the main section or the main act. The Corporations Act is purposely drafted very vaguely, which is where the general and common law comes into play. So, as I briefly mentioned, director duties arise originally from fiduciary duties, which comes from equity and trusts. So, a fiduciary duty, the common understanding is that person A holds an obligation to act in the best interest of person B. So, in this case, a director would form person A and the company would be person B. So, the director must act in the best interest of the company. That's just one example. There are many, many real day examples of fiduciary duties. So doctor-patient, lawyer-client, director-company. And then the next thing we need to consider is who does the director actually owe the duty to? It's very easy to say the director owes the duty to the company, but what constitutes the company? Generally, it refers to the employees and shareholders, but we've got this incoming issue, it's known as ESG. So environmental, social, and governance. Breaching, society standards in relation to environmental issues. So if a company is flagrantly not caring about global warming, the court may constitute that as a breach of the company's interest. So this is something that's sort of coming into play as the courts try and balance society standards with determining breaches. So it's important to understand a little bit more about fiduciary duties. It's a bit of a tongue twister, but a director will always be a fiduciary. However, a fiduciary may not always be a director. It's on that, it is important to note that director duties do extend past the director listed with ASIC. Just because you're not on record with ASIC as a director does not mean that director's duties don't apply to you. So looking at Section 9 of the Corporations Act, an officer is defined as being an individual within the organisation who is accustomed to making decisions that affect the company's business and or financial standing. You'll see in a second, but that person, an officer, will be bound by the director duties as well. The second section of the Act to look at is Section 9B, subsection 2, where it says where a director is not validly appointed, but the directors are accustomed to acting in accordance with a person's directions, instructions, or wishes. They're known as a shadow director, and that person is also bound by the director duties. So the leading case in this area is a recent case that comes from the New South Wales Court of Appeals, determined in 2011. It's a matter of Buzzle operations in Apple Computer Australia. So basically and quickly running through it, it's obviously a lot more complex than these 3 dot points, but Buzzle was a reseller of IT, and they had acquired a series of Apple products. Apple held a charge over those assets, and therefore Apple actually had to consent to the acquisition before it would occur. Buzzle was then placed into liquidation in 2002. Now, you can sort of see here how long and protracted this litigation was. Buzzle was placed into liquidation in February 2002, but the decision wasn't actually reached until 2011. So 9 years of litigation this went on for. So the liquidator of Buzzle issued legal proceedings against 2 executives of Apple for insolvent trading on the basis they were shadow directors of Buzzle. So what was happening was the 2 executives of Apple were providing recommendations to the board of Buzzle on how they should act, what they should do with their stock, and in relation to how they should handle this acquisition. Buzzle was then implementing those recommendations from Apple. I think it went to 2 appeals, but on the final appeal, the court held that Apple, or the executives of Apple, were not shadow directors because although Buzzle felt compelled to act in accordance with their directions, they were not actually accustomed to doing so. The Buzzle board exercised independent thought when deciding to act in accordance with Apple's instructions. So the test there is actually that the board needs to exercise independent thought, debate, and criticism on directions. If they exercise those 3 things and still determine that that recommendation is the best way forward, that person won't be acting as a shadow director, but rather just as an advisor. If the board had just said, you know what, Apple says this is what we should be doing, let's do it, without that independent thought, debate, and criticism, then the executive of Apple would have been held as shadow directors. That's just important to note as to sort of how to avoid being bound by the director duties as a shadow director or an officer or just someone of the company who's accustomed to making recommendations as to how the business should be run. Moving on to our first duty here, so the duty to act with reasonable care and diligence. In the Co-ops Act is found under section 180 of the Act, which states that a director or other officer of the corporation must exercise their powers and discharge their duties with a degree of care and diligence that a reasonable person would. Sufficiently vague. What does that actually even really mean? So the way it's being interpreted, there is 2 elements that the court will consider. So the first being whether there was a possibility of harm or the gravity of harm if reasonable care was not taken would be considered. So have they made the decision and thought it the whole way through? And the second element there is the company's circumstances. So was the decision necessary to ensure the company's survival and had all outcomes being considered in taking that decision? So essentially, would the decision put the company into further debt, or would the decision help the company run past that tricky point? So then the third element, which isn't necessarily there, sorry, doesn't like that. Okay, so it's actually looking for a reasonable foreseeable risk of harm to the company through the act or omission. So if the risk is reasonably foreseeable from the decision, it'll be deemed that you're not acting with reasonable care and diligence. If it's by some unknown occurrence that happens, that reasonable foreseeable risk won't be there. A great example of this was probably in 2019 when a lot of directors were making decisions on behalf of their company. And then the pandemic obviously started in 2020 and a lot of companies were at a loss because of the decisions they'd made in 2019. There was a few decisions there where that said, the pandemic wasn't reasonably foreseeable, and therefore it doesn't constitute a breach of the duty. And just a final thing to note on the actual duty itself, being an exception to the usual rule, there's actually no need to quantify the loss to the company in a monetary amount. You just need to show that the company has been harmed. So you don't need to show, well, the company's at a loss of $50,000. You just need to show that that harm has occurred to the company in order to show that a breach has occurred. Again, when determining the foreseeable risk of harm and the breach, the court will balance the real risk of harm together with trying to continue encouraging that entrepreneurial enterprises. Say that 10 times fast. So there are actually a couple of defenses available to any breaches. It's often called the business judgment rule. This term, though, has come from people watching American TV, and it's not actually something in Australia. We do, however, have a very, very similar safe harbor, but we don't refer to it as a business judgment rule. This is set out within section 182 of the Act, but again, it's best to refer to case law to actually understand what it means. So looking at the matter of ASIC and Adler, the citation is on the slides there. ASIC and Adler confirmed that the defence may only be used if a conscious decision has been made by the director. If an opportunity is presented to the company and the director just forgets about it, doesn't take it up, and then is sued under this duty, you can't rely on the business judgment rule because the director didn't actually make a conscious decision not to take that opportunity. However, if that opportunity came, the director considered it, outweighed the risks, exercised that independent thought, debate, and criticism, and it still resulted in harm, the director may then be able to use the business judgment rule because there was that element of conscious decision-making and thought. So the decision must also be in good faith and for a proper purpose. It can't be, the decision to not act on behalf of the opportunity can't be because the director has a personal interest. The director must remove themselves from all personal interests, inform them as much as possible on the subject matter, and then believe if it's rational and in the best interest. If it appears that the director didn't remove themselves and they do have a personal interest in the decision, which resulted in the harm, then the business judgment rule will not apply. And then the final leading judgment on the business judgment rule is the matter of Rich and ASIC. I do think this went to court about 3 times, but the relevant one is that High Court of Australia citation. That matter showed that the safe harbour is only in relation to ongoing business judgments and doesn't cover their obligation to continually oversee. I know I'm going to use this example a lot, but it's the best sort of way to explain it in basic terms. But looking at a financial position, the director is required to understand the financials. They can't fail to monitor and keep track of them and then say, well, I thought it was in the best interest of someone else. They have to have a basic understanding at all times. If a director doesn't understand or doesn't know the current financial position, at a minimum level, understand, are we in a profit? Are we making a loss? What are our loan repayment requirements? Then the business judgment rule will also not apply. Now, the second defence is being able to delegate. So a director can reasonably delegate. It's under section 190 of the Act, but it must be shown that the delegation was reasonable, made in good faith, and after making proper inquiry. Following those 3 things, if it's shown that the delegate's reasonable and competent, then a delegation can occur. Again, proper inquiry is vague and has been interpreted indefinitely. What is proper inquiry? Is it an interview? Is it looking at references? Is it stalking on social media? There is 4 cases which the courts will use as a starting point. So the first one's the City of Equitable Fire Insurance from 1925. So if there's absence of any suspicion, then the director will be justified in relying on that person. It's probably okay for 1925. 2022, I'm not sure if you can just say, that person seems like a great guy, I thought I would delegate to him. You probably have to undertake a little bit more than that. Second case of AWA and Daniels. So the person being delegated the task ought to, as a minimum, know the fundamentals of the business to guide and monitor management. Next one, directors can rely on management, but they must still be making their own examinations in all matters. This links back into obviously that Apple and Buzzell case we spoke about earlier. So in this specific case, there was an announcement made to market which wasn't correct, and then Hardy tried to rely upon the delegation rule, which was unsuccessful. Then the final case is a bit of background. There was a series of incorrectly categorized loans on the company's books where the director had delegated accounting matters to the accountants. The court said that wasn't good enough, and financial competence is a minimum requirement for directors. However, the accounts remain a board responsibility, and the board should be aware of the business and the timing of any refinances. That again goes back into that ASIC and Rich case. So it's fine to delegate the preparation of accounts, but directors and the board must have a minimum understanding of, the timing of refinances and the current financial position. So that is the duty to act with reasonable care and diligence. It's a bit of a mix of statute and common law there. I forgot to mention, if anyone does have any questions, feel free to pop them in the Q&A box, and I'll answer them as I go if I see them. Otherwise, you can ask questions at the end. That's no worries. This is just a case that I find gives this duty great context. So it's the case of ASIC and Casamartis, number 8. So it was litigated 8 times, determined in 2016. So the defendants in this matter were the managers, directors, and shareholders, although shareholders who held a high degree. The defendants were engaging in a scheme which encouraged their retiree client base to remortgage their home and then use that money from the refinance to purchase shares. The court held that the defendants were in breach of Section 911A of the Act, which provides that a company must hold an AFS license to provide financial advice, which Casamartis did not in this case. The company then further held that because the defendants were allowing the company to breach another section of the Act, the defendants were therefore also in breach of their duty of care owed to the company. So by allowing a company to breach the Act or engage in illegal conduct, you're then breaching your duty to act with reasonable care and diligence, because there's obviously a reasonable foreseeable risk of harm in breaching any statute. So it's what's now known as the stepping stones liability. So if a company holds a reasonable foreseeable risk of contravening the law, then it'll be deemed that the directors have breached their duty of care. So again, you don't actually need to breach the law, it just needs to be foreseeable that your actions will breach the law. So moving on to the duty to act in good faith and in the best interest of the company. Again, this is set out in Section 181(1) of the Act. And the court looks to find that a director has acted in bona fide good interest. So on the face of it, they've acted in good interest. The court then applies a pub test. So the court will look at whether a reasonable director in the same person would have made the same decision. It's a common theme, but the phrase best interest is ambiguous at best. When determining what is best interest, the court looks to employees, stakeholders, and whether there is an alight and self-interest of the director. It mainly occurs in large publicly listed companies, but if a director can be replaced by the shareholders. So a director previously tended to act in the best interest or per the shareholders' directions, which then meant the director had a enlightened self-interest in doing so because they got to keep their position. So the court will look at whether that's occurred or whether the director made that independent self-thought as to the direction. There's actually also further discussion around boards of holding companies and those companies which have subsidiaries. So does a director of a holding company then owe the duty of care to the holding company and all the subsidiaries. Currently, the way it's drafted is entity specific. So you may have a series of subsidiary companies, but your duty is only to the company of which you are directed to. Keeping in mind that term of officer and shadow director, there may be times where that extends to the subsidiary companies if you have everyday, day-to-day involvement with those subsidiaries. But if those subsidiaries have their own directors and boards, then your duties are minimized to the company that you sit on the board of. That being said, Section 187 of the Act does provide a carve out in that a company's constitution can allow a director to hold a duty to act in the best interest of a holding company and a subsidiary company, only as long as the subsidiary company remains solvent. Speaking of solvency, if we move on to a little bit of insolvent trading, so under 588G of the Act, a director must avoid insolvent trading. There is also a general law duty under Section 181, which requires the director to avoid the company trading insolvently. How this interacts with the duty to act in good faith in the best interest, we refer to the two cases of Kinsley and Another and Russell Kinsley Proprietary Limited. So it will be in the best interest of the company to have regard to all creditors when the company may be insolvent. So if you are not acting in the interests of creditors and you know the company is insolvent, not only have you breached your duty to avoid insolvent trading, but you've also breached your duty to act in good faith and in the best interests. That case was then reaffirmed in 2007 in the matter of Coles Enterprises Proprietary Limited and Belgolo, which stated there may be situations where the company is just short of insolvency, however, creditors' rights are still prejudiced. So if you know you are likely to become insolvent shortly, and you don't take action to place the company into administration, have a chat to insolvency practitioners, you'll still be breaching that duty to act in good faith, even though you're not yet insolvent. Just a final point on this. So there is many occasions in which a director makes a decision now which affects the company in the future. In between making that decision and the decision coming into play, it's quite often that a company's circumstances change, and by the time the decision comes into effect, it's actually no longer in the company's best interests. The court won't compel a director to proceed with that decision, even though against the best interest, even though the decision was already made. But it is important to remember that backing out of that decision may mean the company owes a liability to a third party if it rescinds on its prior decision. And that's just due to any losses of the third party by, backing out of the contract or deciding not to proceed. So on that point, it's actually not uncommon to see sort of carve out in commercial contracts, which allows a company to back out if it's no longer in the best interest of the company. So the duty of loyalty. This one does arise from common law, and it is broken down into two different prongs. So the director must not be in a place of conflict, and the director must not profit from the fiduciary duty. So first, if we look at the duty to avoid conflict, a conflict is said to occur when a director is placed in a position where they may be tempted to prefer their own interests over the interests of a company. Now, the leading case in this is Boardman and Phipps. It is a UK case, but it is influential in terms of Australian judgments. So that defines a position of conflict as being where there is a real sense of possible conflict between personal interest and duty. It's very basic. Essentially, if you think you're in a position of conflict, you probably are. And based on that, the courts have actually taken a very, very strict view in determining whether breaches have occurred. There just needs to be a sense of conflict rather than the actual conflict to be determined a breach. So again, if you're sitting there thinking, I might be in a position of conflict here, I'm not sure if I can do this, you've probably already breached your obligation to avoid a duty of loyalty. There is Section 191 of the Act, which does provide that a director has to disclose material interests to the board. Section 191 does have a series of exceptions where you don't have to, but as a general rule, we always recommend if you think you've got a material interest or a potential conflict, just disclose it to the board. Now, the second part is profiting from fiduciary duties. So you can't make a personal profit from your position as a director. If it's found that this has occurred, the director will actually have to pay back any profit to the company. So any personal profit you made from your position will be ordered to pay back to the company as it's deemed it should be company's profits. We're actually lucky in this one. There is a series of case law that sets it out really nicely what does constitute a breach of profiting from your fiduciary duty. So the first one here is Furs Limited and Tomkeys. So it's irrelevant as to whether the company would have obtained the benefit. A company's constitution may allow for a director to obtain a benefit if that profit is disclosed to the board, generally before that profit's been incurred. But if a company's constitution doesn't have that clause, disclosure itself will not actually cure the breach. So if you don't have the clause, you make a profit and you disclose, there's still going to be a breach of the duty and you're still going to need to pay that profit back. Assuming it goes to court, generally boards and directors can settle that pretty amicably. Second one there is Warman International and Dwyer. So the court may make allowances for a director's skills and expenses. So when assessing the severity of the breach, the court will have regard as to whether the director's skills alone were the cause of the profit and whether the director incurred any expenses. And if so, it will award the difference to be paid back to the company. So essentially, if the directors made the profit due to their own marketing skills and their own selling skills, and they've taken someone out to lunch, that will be taken into account when determining how much the director has to pay back to the company. Now, these two cases are Canadian, but again, they are very influential in terms of Australian law and how the Australian courts are interpreting the duty of loyalty. So the first one gives a little bit of context, but following the resignation of the director, that director then immediately formed his own company and tendered for the same opportunity being considered by his former company. The court held that the resignation was influenced by the current opportunity before the original company, and therefore that was a breach. If the director had resigned on his own independent thought, then a fresh opportunity arose which placed him in competition, no breach would have occurred. So the issue was the opportunity was before the company. The director became aware of the opportunity in his position as a director of the first company, and therefore, following his resignation and tender for that same opportunity, he's profited from his position as a director of the first company. And then the second one is Pesto Silver Mines and Cropper. So it largely follows the same facts. However, in this case, the defendant did not breach his obligations because the board had actually rejected the opportunity before the defendant had resigned. So it wasn't a fresh opportunity still being considered by the board. They said, no, we're not proceeding. The defendant said, I thought that was a really good opportunity. I'm going to go out on my own and pursue it. And that's not a breach because the company had already said no, and therefore the company wouldn't have incurred a profit from it in any event. What's the time? So we move on to the duty to avoid improper use of position and information. These ones are a lot less content heavy and they're pretty straightforward. So duty to avoid improper use of position and information is set out within sections 182 and 183 of the Act. So section 182 is the misuse of the position and 183 is the misuse of the information. A breach occurs when a director seeks a personal advantage or to cause detriment to the company. Based on that, it is common to see the breaches of duty of loyalty pursued under Section 182 and 183, because you need to have a section of legislation you're suing under to be able to bring any application. So the court will also look at the person's purpose rather than their motive. The difference is that the purpose considers what the director is trying to achieve, whereas the motive looks at why the actions were being occurred. An example here is a director may be attempting to contravene a breach of a section for whatever reason, and then fails in that attempt. It's still going to be a breach because we're looking at his actions. So we're looking at his attempt to breach or contravene a section. Again, that's confirmed in the case of ASIC and Mitchell. Number 2 is the purpose which counts, not the motive. It is well accepted that purpose and motive are not the same thing. The purpose of conduct is the end sought to achieve. Motive is a reason for seeking that end. So you might have a reason for doing it, but the court won't necessarily look at that. They'll just look at your purpose of the conduct. So are you looking to breach your duties? And if the court determines you are, there will be a breach of the duty to avoid improper use of position. So we can move on to the consequences now. There is the 4 main consequences there. So equitable compensation, these are all different types of orders or remedies that a court may order if it's determined that a breach has occurred. So equitable compensation is in the form of damages to be calculated by the court on the severity of the breach. So for example, it's okay, purposeful actions or accidental actions. So has a director set out on their day with an intention to breach their director duties? Or is it a director of a startup company who is not entirely sure as to his director duties and has accidentally breached a duty? It is, we should note, maximum payment is up to 200 grand for a breach of director duties, 5 years imprisonment or both. So when looking at equitable compensation, it'll be payment up to 200 grand, or 5 years in prison, or payment of 200 grand and 5 years in prison. Now, the main order sought by ASIC recently is this penalty order. The main purpose is to punish the offending rather than compensate the company. So if it is a deliberate action and it's only resulted in the company suffering loss of say 50K, ASIC will seek this order and you may have to make payment of 150K to the company. Justice Santo has summed it up really well. It is a personal and general deterrent to prevent the corporate structure from being used in a manner contrary to commercial standards. So it's essentially sending a message to the rest of the corporate community that the courts and the ASIC won't accept this behaviour, and you can expect some severe punishments if you do participate. If ASIC's been on your back for years and you continue to act in the same manner, ASIC can seek an application to disqualify you from acting as a director of future companies. So if there are repeated breaches, or if the breaches cause a significant amount of damage, reputational or economic, they can seek an order for the director to be disqualified. It's probably important there to note that reputational issue as well. So you may not have caused necessarily significant losses by your actions, but if you've caused that reputational damage, so if you've made news for dumping oil or something along those lines, ASIC may still seek an order for you to be disqualified. And then finally, and this is normally the order they seek against those entrepreneurs who are just giving it a go, is a compensation order. So it simply seeks that the director pay back any loss to the company. So the company is in the same position as if the breach did not occur. So now we've gone through the duties and what might happen if we breach them. It's important to talk about how to avoid breaching them in the first place. So these are just some recommendations we have to help. So create and maintain a conflict of interest policy and register. So it provides that all conflicts of interest must be registered, and a module on how the company will handle internal conflicts. Disclose any breach as soon as it occurs. This one is paramount. So if you have accidentally breached your director duties, disclose it to the board immediately. And if it warrants it, obtain legal advice. It goes back to the old saying, honesty is the best policy. As soon as something occurs, breach it. So as soon as something occurs, disclose it, and sort of work with the board. Claims for breaches of director duties will sort of only come about if ASIC gets involved or if, shareholders bring a derivative action. But 9 out of 10 times, these things can be settled at a board level just through having a discussion. The third recommendation is to execute a deed of warranty and indemnity. So it provides that the company will indemnify the director for costs incurred in their role as a director. So it may be limited in providing indemnification for direct breaches of the Act, but can assist should that derivative action or something along those lines occur. Or obtaining directors and officers liability insurance. So if you have the correct policy, the director can be reimbursed for a portion of their legal costs arising from decisions you have made in your capacity as director. Again, sometimes insurance companies are a bit funny if it's shown that you've deliberately breached your duties, but generally you can obtain some pretty good D&O liability insurance. So provide director onboarding training. It's really important that a director is aware of the company's operations and strategies. Onboarding should be provided to ensure a director is up to speed and able to contribute at a board level early on. So director duties come into play as soon as that director is listed with ASIC or as soon as they start making decisions. So right away, that director needs to be aware of the company's operation strategies and the types of decisions that the company is making, though there's no sort of grace period for the duties. Continue to encourage professional development. So the legal landscape is always changing and adapting. We do recommend that all directors undertake the AICD Company Directors course at the commencement of their role. That course we've found provides a great overview of directors, what's required of them, and again, speaks about some director duties and what they can do. Then the final one is to get regular board training from lawyers on legal risks and consideration. So following the company directors course, because the legal landscape does continue to change, just ensure there is regular legal training provided to the board and ensure all members are kept up to date and are well aware of their obligations. Now that, I believe, concludes the formal part of today. If there are any questions, I'm happy to answer them. If you prefer, you can send me an email, connect with me somewhere, or give me a call. I don't think there's any questions.
All right, great. Well, on behalf of Law Squared and Jackie, we just want to thank everybody for joining us for today's CPD session. And obviously, thank you, Jackie, for putting on a great session and running us through some great information. We will circulate a copy of the presentation as well as the video link. So if you do want to have a look back over anything or you missed anything, you'll have all of that provided to you. And aside from that, thanks for joining us and have a great day.
Thank you.